From next time, I'll give it to one of the hosts. Okay. Yeah. Now you all can see. Yes.
Yes,
Yes.
ma'am.
Yes, ma'am.
Yeah.
Now it is
From next time,
visible.
I'll see to it that my co-host gets it. Okay. One of your leader will get, team leader. Huh? Yeah. So this is lien. A claim upon a part of another's property. Now this is my property. The money lender is keeping a claim on this property that arises because of an unpaid debt. So in this particular statement, you need to stress upon three important points. Remember, in law, now the first definition just split it into three parts, so you will know the entire concept. Otherwise, if you will not know the first portion, the entire portion you will not understand. So over here, number one is claim. Please write down claim. Number two, another's property. Number three, unpaid debt. Those who are answering need to answer me this way. It's a claim. Number two, another's property. And number three, unpaid debt. Now related to the property, and that operates as an encumbrance on the property and the debt. Now encumbrance, I know some of you are not from the legal background, but encumbrance means I cannot sell this again to somebody. Can I sell this to Swati Menon? Can I sell this to Swati Menon? No, because it is now belonging to the money lender, right? Right? So it is an
Yes, ma'am.
encumbered property. It is an encumbered property. If I don't pay, he is going to take it away from me, right? Yes. So
Yes, ma'am.
encumbrance. So encumbrance is very, very important. Please remember, next session, your finance session is beginning. Property, company law is beginning. So you will have all these words again. So encumbrance. So the fourth point you will remember in lien is encumbrance. That is ENCUMBRANCE on the property and the debt. Now, yes, the definition of a lien is a claim, right, on the property as security to make that particular person repay the money back. Fine. So we'll see the right of lien is very important. You will see the possession is important. That particular moneylender should have the possession of this property. Then only he will have the right of lien. He will retain my goods if I don't pay back, only if he has the possession. So now 5 important points when a question on lien comes. The fifth one is possession. The fifth one is possession. Next, yes, the very important concept of letter of credit. Now what happens is in import and export transactions, it happens that one of the party may not be able to make the payment. So his banker promises it with a particular document called the letter of credit. So we'll see over here, the letter of credit or the credit letter is a letter given by the bank that a buyer's payment to a seller will be received on time. The buyer's payment for the seller will be received on time and for the correct amount. Maybe it's for 20 lakh, 30 lakhs. Somebody in your class is an exporter. She's exporting jeans and to London and some friend over there. So she is unable to pay. So her banker will be issuing a letter of credit. Okay. Fine, all of you? Yes? All of you understanding
Yes,
the
ma'am.
letter of credit?
Yes, ma'am.
Yes, ma'am.
Yes. So letter of credit is in the event the buyer is unable to make a payment on the purchase, the bank will be required to cover the entire amount without, that is on account of the purchaser. So the particular banker in our class, we are having a banker. Who is a banker in our class?
Ma'am, Viral.
Well,
Yeah, Viral is there present today.
Yes, ma'am, I'm here.
What's your full name, Viral?
Viral Khatri.
Okay, Mr. Khatri is a Canara banker and he is giving the letter of credit. So we'll see the procedure in the next slide, what is happening. Now here, there are the various types of letter of credit. Yes, transferable and non-transferable. revocable and irrevocable. Of course, standby letter of credit, confirmed letter of credit, and unconfirmed letter of credit. Someone will be doing in the class a project on this later on for the 40 marks. So they'll be describing each one over there. And that is, yes, revolving, back to back, red clause, green clause, all these are the letter of credit that a banker use. For this exam, you need to know the procedure, how the letter of credit procedure is. We having the buyer, we having the seller. The buyer is buying the jeans in London or maybe the designer wear in London. So she's preparing a sale contract with the seller who is exporting. Maybe one of you in the class is the exporter. Can you give me a name other than the observer? Can you give me a name?
Vishal Mehta.
Vishal Mehta is the exporter of jeans. And yes, someone is buying it. Who is buying it? Give me a name, someone.
Vipul Trivedi.
Yeah, Vipul Trivedi in London is buying all is, the designer wear. So you are the importer and you make a sale contract to the seller. And of course, the seller is contacting his, yes, the exporter bank, the advising bank. And these advising bank give the letter of credit. Okay, you can see the arrows over there. He's giving the letter, delivering the letter of credit to the seller. And yes, of course, discount, the documents are given, he presents the document. The exporter's banker, for example, our banker, Canara Bank, gives the documents of letter of credit to the importer's bank in London. Okay, the letter of credit is given to the importer's bank, and that importer's bank makes the again gives the document and claims to the buyer. So that is, he is requesting the credit. Okay, so this is the procedure. In short, what you need to remember for the exam is that a banker is guaranteeing the payment on behalf of the exporter. Sorry, the one who is purchasing or selling, the one who is selling the jeans, the designer wears, and the buyer is unable to pay. So therefore, the banker is guaranteeing the payment. Okay. So we having the right of lien, the right of set off, and yes, the right of issuing letter of credit. So all these are very important in your 5th and 6th module of banking and finance. So here we are going to conclude today with one more right of a banker, which is coming under contract law, that is right of set off. Again, right of set off is a banker's right. For example, you will see the reduction in discharge of a debt. I'll first give you an example. For example, I have taken a car loan from our Canara banker. Who is the manager? I forgot his name.
Viral.
Yes, ma'am, Viral.
Viral, please come on the screen now. I'll forget your name, Viral. You're the banker. I need
Yes,
to
ma'am.
recognize you. Hi. So Viral,
Hi,
you
ma'am.
have given me a car loan. You have given me a car loan of 20 lakhs and you have given me a housing loan of 50 lakhs, right? Yes. So after 6 to 7 months, I got some 30 lakhs and I'm going to pay back to you 30 lakhs. Okay. So you have the right to adjust in any of the loan, either the car loan or the housing loan. Fine. So if you feel like finishing off the car loan, you can tell me, hey, ma'am, we will finish off the car loan first. So I will adjust the entire amount to the car loan. Okay. So what are you doing? You are setting off the debt. Okay. Yes. So we will, as a banker, has very important right. This is a special relationship that he has because he entered into a contract with me while giving the loan. He has a right of set off. Okay. So you also have the right of lien. The banker also has the right of lien. If I won't make my payments, the car payments, you can keep my car documents. You can keep my car documents. You have a right to retain my documents unless and until I pay all the EMIs and the entire loan, you will not give me the car papers, right? So you have a right of lien. Then you have a right of appropriation. You have a right to charge. and you have a right to set off. Of course, you have the power to issue letter of credit also to, if your client is an exporter or maybe he's buying or selling something, you have a right of so many things. As a banker, you have rights. So in the contract law, special contracts, we are finishing off with these three important rights, which is very, very important for your case studies. Your case studies will be coming and you have to answer which is the right that he can use. So this is the right of set off. So right of set off, yes, it is an equitable right of a creditor. Now he is the creditor in the screen, the banker, to deduct a debt it owes to the debtor, yes, and from its claim it has against the yes, against all the debts he can prefer one of them. So we'll see in the next slide a very important example. Can you read out, the banker? Can you read out, Viral?
Yes, ma'am.
Read out loudly like a banker.
Banker's right of set off.
Yeah.
The right of set off means combining of two or more accounts, say overdraft and fixed deposit,
Yeah.
one of which is in debt and the other is in credit.
So
In the
you,
same branch
so how much,
or in the
listen, how much money I have in your bank? It's there on the screen. How much money I have in your bank?
700.
7,000?
7,000.
7,000 I have, right? And how much money, what is that? How much money I have in the account? You're the banker. Read again, read.
The
Can
right
you read?
of
Yeah.
The right of set off means combining two or more accounts, say overdraft and fixed deposit, one of which is in debt and other is in credit.
Viral, you're going to become the manager. Speak loudly.
The right of set off means combining of two or more account, say overdraft and fixed deposit, one of which is in debt and other is in credit, in the same branch or an other different branch, subject to certain conditions.
Yes.
A banker, like other debtors, possesses the right of set off, which enables him to combine two accounts in the name of same customer.
Yeah,
And
I am your
adjust
customer.
debit.
I am your customer. I'm having two accounts with you. Yeah. Speak.
And adjust the debit balance in the account with the credit balance in other.
Yeah.
Example is, suppose A has taken an overdraft from his banker to extent of 9,000 rupees. And he has credit balance of 7,000 in his saving
So
bank
now
account.
wait. Now I'll ask you some question. You need to answer me as my manager. I'm having how much money in my account?
7,000.
My account, how much money I have? 7,000. 7,000. Huh? Yes. And how much I am asking you?
9,000.
Yeah, I'm asking you 9,000, right? So 2,000 is the overdraft you're giving me. Yes. You're giving me 2,000 overdraft, right?
Yes.
2,000 you're giving me, na?
Yes.
Now you'll see the next sentence. See the next sentence.
The banker can combine both of these accounts and claim the remainder amount of rupees 2,000 only.
So next month, what will you tell me? Hey, ma'am, you already had 7,000 in your account. Just give me back 2,000 rupees. Right?
Yes.
In simple sentence, you will talk like that to me, na?
Yes, ma'am.
Right, na? So that's called the banker's right of set off. Easy?
Yes, ma'am.
Yes? Yeah?
Yes.
Please write down your question. Please write down your question. Sorry. We have around 80 slides and plus videos to be shown. Please. See, now this is the easiest way we can understand. The banker is there and I'm asking is an easy question. It's just how much money I have in account. He's combining both the account and he's telling me you just pay 2,000 because you already had. So that is called the right of set off. Okay. CR plus, just write the name of the person who had a doubt.
Yes, ma'am.
All my 3 CR, please be alert. Vansh.
Yes, ma'am.
Please be alert. Somebody had a doubt.
Yes, ma'am.
We are to show the videos also. So if in case another 15 minutes, if I take off explaining, no, we will be losing time. Yeah, so contract of agency, these are the important things which we need to do. Contract of agency is there, the principal and the agent. Of course, we have to do the special contracts. We already did the letter of credit. We finished the lien. We finished the set off. We finished the bailment. We finished the pledge. All are very, very important for your exams. Then, yes, the important clause of commercial and corporate agreements, very, very important. That we'll be finishing off today. Important clauses in corporate and commercial agreements, and also important clauses in employment and employee agreements. Okay, so whenever you're entering into a contract for employment, you're going to sign some printed documents that particular lawyers of that corporate has made. So each and every clause is important. Similarly, when I am sitting here in my office and drafting commercial agreements and corporate agreements, even for my international clients, we do it now through, because of the opening up of the global economy. It's not that I have to be in Singapore to prepare a document for my clients in Singapore. So we have to draft the corporate agreements, and we see to it that each and every clause is drafted very, very properly. Because agar kuch breach hua, that particular parties, the promisor and the promisee will not get justice in the court, because that clause is not there in the agreement. So therefore, the lawyers made this. Number one is C for confidentiality clause. Please write down, all of you. If I am setting the paper, either of one can come for your exam. Special contracts. If I might put this, draft the important clauses in corporate agreement, or maybe draft the important clauses in employee employment contracts. So number one, for the corporate, it is 1C for confidentiality clause. You know that when we enter into agreements between two parties, there are so many things that we discuss, we exchange information, extremely significant, extremely confidential things we enter into contract. So therefore, the number one important is C for the confidentiality clause. The next is, yes, obligation clause. What are the duties of the promisor, the promisee? Maybe delivery of goods, maybe the quantity of goods, maybe the quality of goods, maybe the time, whatever it is, the obligation is very important. Obligation clause. So C for confidentiality, O for obligation, F for force majeure. Please never forget the force majeure clause in exam, because now you're going through this. The force majeure is act of God. Section 57 of the Indian Contract Act, 56, Section 56 of the Indian Contract Act, that is impossibility, non-performance of a contract due to unavoidable circumstance. Non-performance of a contract due to unavoidable circumstance. You see the COVID-19 situation now. You all had entered into a contract with your institution, and you all had paid extremely heavy fees for your, library facility, for your gym facility, for meeting, faculties. Yes, well-known faculties you could have met in the campus, right? But now, this particular clause you cannot avail because of force majeure. Got me? That is act of God. Frustration of contract. It is called the contract frustrated. So if any of the party goes to the court, in such cases, the court will not listen, because it is impossible that I am in the campus with you. I'm not going to come in the campus to meet you all. So similarly, you all come to the campus to have the library facility. So this is a very threatening situation. So this is simple force majeure. Force majeure. So the class got the first one, confidentiality clause. Second is the obligation clause. Third is the force majeure. The clause is written that in case anything happens which is unavoidable circumstances, then no party will be responsible for, either of the party will not be responsible for any breach of that contract. Okay, so that's impossibility. We'll be doing, today is our last session on contracts. So I would like to speak here a very important case study on section 56 of the Indian Contract Act, which last time we had skipped, that is Krell versus Henry. Please write down Krell versus Henry. In my PPT, when I'm sending the PPT, kindly remind me to add this case. Yeah, both of you. Okay,
Yes,
Suyash,
Yes.
I need to add the case of Krell versus Henry, a very important case study for your exam.
Okay.
In Krell versus Henry, what happened was Henry had purchased a flat on rent to view the king's coronation ceremony. The king's coronation ceremony was there in Britain, and he had booked a flat, an apartment to view the coronation ceremony. He paid the rent, half of the rent he paid, I mean the deposit he had paid, but unfortunately, the king fell sick. The king fell sick, and the coronation ceremony got cancelled. The coronation ceremony got cancelled. So there was a breach of contract. So the other party went to the court claiming that Henry need to pay the remaining rent. Henry need to pay the remaining rent. But the court decided that this is section 56 of the Indian, that is British laws. We are following the English laws. So they said, yes, it is frustration of contract, and therefore Henry need not pay. Okay. So Krell versus Henry can come for your exam. It is very easy. Section 56 of the Indian Contract Act. In commercial and corporate agreement, we make the third clause or any of one of the clause as force majeure. Force majeure clause is impossibility to perform due to unavoidable circumstances. We already saw in our first lecture, we saw that Ritu Kumar was in a position impossible to, perform her part of the contract because her mother had fallen sick, and therefore the court had made the agreement and allowed the novation of contract. Okay, fine, all of you. So the fourth one is very important, termination clause. The termination trigger clause, yes, this is very important because in case anything happens, either of the party does anything wrong, maybe the employee does anything wrong, or maybe, in this case, it is the corporate agreement. So the promisor and the promisee, if they do anything wrong, the contract can be terminated, especially anticipatory breach or whatever, the contract can be terminated. The next is dispute resolution and jurisdiction clause. Yes, jurisdiction clause, this is where we the lawyers come in picture. Okay, so don't forget J for jurisdiction. Yeah, so we have the importer and the exporter in the class. Yes, the importer and the exporter. Can you come on screen, please? Please, all these examples are very important. I need to recognize you now. The classroom is very different, you know. Yes, the students can get to see just next to me, both of you will be standing and the class understands the code, you know. Here it is very difficult unless you appear. So what's your name? Vishal. Okay, Vishal is importer or exporter?
Exporter.
Exporter. So you are based in India and you are sending all the designer wares to London, the importer, right? Yes.
Yes.
So in case something goes wrong and you are not in a position to perform your part, then it becomes a breach of contract, right? So in the contract, I will be drafting for you. Maybe it's, 20 lakhs, 40 lakhs ka contracts that you both are doing. I can't see the other one.
Yes, ma'am.
Yes. Then I'll also
Yes,
go off
ma'am.
screen.
Yeah.
I too will go off screen.
No, ma'am. I'm there.
Okay, so both of you are the importer and the exporter. So if I will
Yes.
make the contract for the, he's in India, he's in Mumbai. So I'll draft the contract and I'll write over there the jurisdiction clause. So in case anything happens, if he's not in a position to perform his contract, we will put Mumbai, the Mumbai High Court or the Mumbai Sessions Court or whatever for damages we will put there in the clause. And Mumbai will be the place where you have to come from there. Okay, we will not come there. So both of you agree the jurisdiction clause. Okay, beforehand, before you deliver the goods, you both sign the contract. So you agree that yes, in case कुछ भी हमारे बीच में हो गया, so the court will be Mumbai. Hema ma'am will not be coming to Delhi, or I won't come to London also. Now तो बिल्कुल नहीं, है ना? Right? So that is the jurisdiction will be Mumbai, right? Both of you understood? You have to
Understood.
explain to
Yes,
the class, huh? I'll call out your
Yes.
names.
Yeah.
Okay, so yes, the
Yes.
jurisdiction clause. Okay, now again, if both of you don't want to go to court, both of you feel as an importer and exporter, the lawyer will be charging 10-15 lakhs, right, to appear in the court. So why do we want a lawyer? So let us go for alternate dispute redressal. Okay, let us go for ADR. So in the clause, after the jurisdiction, if we are not mentioning a court, we write over there, we appoint advocate so-and-so as the arbitrator. Okay, arbitrator means I will, if a dispute arises, I will just decide as a quasi-judicial authority, not like a judge. In the jurisdiction right, you're writing about which judge will handle your case. The judge will punish with exemplary damage, whereas me as an arbitrator will think both the sides and decide a case. So both of you need to agree that yes, she is going to be our arbitrator. Got me? Yes?
Yes.
Yes, ma'am.
So that is the jurisdiction clause. Jurisdiction clause, and the next is the yes, very important one, that is dispute resolution clause. Appointment of an arbitrator. Appointment of an arbitrator. We having a special session on ADR. We having one session on ADR, alternate dispute redressal, where I'll be training you all on arbitration, conciliation, and mediation. Arbitration, conciliation, and mediation. These are the three very important alternate dispute resolution. क्योंकि कोर्ट में तारीख पे तारीख होते रहता है, right? And we lawyers charge every तारीख, we charge lakhs of rupees. So you know the fees goes high. So better whatever the business transactions they do is they write that we'll appoint an arbitrator. This will be the fees. Okay. So similarly,
Yes.
in my session, I'll be explaining to you conciliation and arbitration. It will come around in the last. In the end, it will be coming arbitration, mediation. In many of my cases in the court, goes for mediation. If I get a time, I will explain to you some of the very famous cases I have won, and where judges have sat as mediator. Judges sit as mediator. You can request, you can request a judge because both the parties are very influential. The lawyers, if they sit as mediator or somebody, it can be manipulated. So the judges also sit as mediator. I'll tell you one of my cases. Okay. So now you understood the dispute resolution clause. Now can one of you speak the 5 clauses loudly so that
May
the
I?
class is alert? Yeah. Any one of you.
Yeah. So the first is the confidentiality clause.
Very good.
The second is the obligation clause.
Please
The
speak
third,
loudly. The class
yes,
is
ma'am.
listening to you.
Yes, ma'am. So the first is the confidentiality clause. The second
Yeah.
one is the obligation clause. The third
Yeah.
one is force majeure. Uh,
Yeah.
the fourth one is termination trigger clause. The fifth
Yes.
one is jurisdiction clause.
Yes.
The sixth one is resolution, in which there is
Yeah.
alternate dispute redressal.
Yes.
And the seventh one is damages.
Yes, the last is important, damages. We already saw in our first session the moot court where our Vansh, the leader, had become Ranveer Singh and he is screaming in the court, I want exemplary damage. Huh? I want exemplary damage. So that is a clause where if the lawyers draft the damages clause, that is liquidated damages. We write there, in case you both, the exporter and the importer, fail to perform each of your promise, maybe 5 lakh, maybe 10 lakh, we write liquidated damage there, a particular amount, estimated, a pre-estimated amount. I'll ask both of you, Baba, kitna likhna hai? Okay, so I will call up the person in London also. Can I write 5 lakh as the liquidated damage? Okay, so both of you agree for a pre-estimated monetary compensation. Liquidated damage are pre-estimated monetary compensation. All of you, the class, Are you understanding my legal language?
Yes, ma'am.
Yes,
Yes,
ma'am.
ma'am.
Because that's why I'm putting students there to repeat it.
Yes,
Okay?
ma'am. Yes, ma'am.
I know
Yes, ma'am.
most of you are engineers, but I'm so sorry because being a lawyer, our legal language may be very fast. Okay? So all of you understood liquidated damages? Yes, liquidated damages are pre-estimated damages. Now this is employment agreement. Whenever you all are going for an employment, yes, thank you both of you. Thank you. Yes.
Ma'am.
So employment agreement. When you are going for an employment, there is supposed to be a contract you all make over there, and that is extremely important because there are various clauses where you will be posted, where you will be, trained, where you will be have to go in emergency situation depending upon your employment. So before you sign, you see 10 times what will be your payment, then you will start comparing with another somebody who is ready to give more salary. So these are employer and employee contracts. Number one, the employee contract is a written document between the employer and the employee. It defines the rights and responsibilities between the two. So number one is rights and responsibility. Rights and responsibility. So tomorrow, if somebody is entering Barclays, okay, I have been teaching for the last 10 years and my students have reached excellent places. I'll try to call some of them in one of our sessions so that you are encouraged. Okay? Don't worry that you are in a situation, you all are at home. In another 6 months, I'm sure you will be, in another maybe 8 to 9 months, you will be appearing for interviews. And these are the things you will be seeing in your contract. That is number one. Yes, the responsibilities, the duties. Of course, it defines the rights and responsibilities. It is generally for management, that is the higher level management, which who have to share and who have access to sensitive information. Most of you will be joining in the managerial cadre. So naturally, when you are in managerial cadre, you will be handling sensitive information. So you will find always they get signed your document. Okay, you have to sign a document. So these are the important things. The statement must contain certain terms and conditions, a contract that gives both you and your employer certain rights and obligations. Of course, yes, the most common example is that you have a right to be paid for the work you do, and similarly, your employer has a right to give the reasonable instructions to you and for you to work in that job. So if anything you do wrong, maybe negligent, maybe something which you are creating a mess out of what has been assigned to you, the employer has the right to terminate. So these are the obligation clauses, the condition clauses, the obligation clauses, the termination clauses. Naturally, you have one more thing, that is suspension condition. In case anything goes wrong, your services can be suspended. So there was a very interesting case of one of my students who was working in dockyard. Okay, a real life case. The class is listening. Yes.
Yes, ma'am.
Yes,
Yes,
ma'am.
ma'am.
Yeah, this was one of my LLB student. Yeah, one of my, if I say some interesting cases, no, it will be more easy for you. So he was working for the dockyard, and that's a government organization. He's not supposed to go on. There are particular clauses which he signs when he enters, especially when we enter government sector. For example, my first duty when I entered the customs, we are supposed to read. We have to take a oath in the name of the President of India. If you're entering a government sector, you take the oath on behalf of the President of India that I am working on behalf of the President of India. And whatever the clauses of agreement is, that administrative officer reads out, and you have to say, yes, I agree. You sign there on the first day. These are for government exams. And even for public sector, you have it all. So naturally, I don't know about private sector because I haven't worked. Now I run a private sector. So I see to it that my juniors, they sign all this confidentiality clause. So government sector, we have this. So this guy was working for the dockyard, and he was around 57, 58. So he thought, now I am going to retire, so let me put up a shop. So he put up a shop, a small shop, and he started sitting in that shop, and he started, sitting and enjoying his new work as a shopkeeper. But over there, the dockyard, the administrative department, HR, came to know that he is doing this over here, and he has given his sick leave. Now, usually in government sector, what happens is when a particular contract is signed, you often get your earn leave how much, your sick leave how much. Usually, for example, when I was working for Reserve Bank of India, we are having 30 days earn leave. I can take 30 days in a year earn leave. Maybe I'll take this month, this week I'll take 5 days. Then I'll go to office, then another 5 days, then again another 5 days. In September, I'll keep another 5 days. So totally, I will be having some 30 days earned leave. That means I can be at home and the Reserve Bank gives me the payment. All of you understood? Yes, that's called earned leave. So we are having 30 days of earned leave. Similarly, we are having some days as sick leave. Sick leave, like for example, they will tell you you can take 3 months sick leave. So someone falls sick, maybe they get jaundice, so they cannot go for 3 months. They can extend that, provided doctor gives certificate, but that will be without pay. Extension of the 4th month, 5th month will be without pay. All of you are getting? Yes? Because I signed that in a year, I'll get only 3 months. Usually it is 1 month sick leave. I just gave an example, 3 months. Now, maternity leave. Yeah, maternity leave, we signed that if we are, yes, of course, women. For the men, it is, I think so now, 15 days maternity leave because they started fighting for equal rights. So for the women, it is 6 months maternity leave. So if we are taking 6 months leave, I have to take only 6 months, and this 6 months, the government, the Reserve Bank gives me the payment. 6 months, I don't have to go. The bank account will be there. Every month, they will be crediting the salary. So this is called all the leave I have signed on the first day I enter the Reserve Bank. This will be my leave. So if I take more than that, 6 months more than that, the Reserve Bank can take action. And now, yes, now because of all this heightened amendments in your Industrial Dispute Act, women can take 1 year. They can take 1 year. So the next 6 months will be half pay. For that also, she has to give a gynecologist ka certificate or a pediatrician ka certificate that the baby requires. The baby requires the mother. So the doctor certificate has to be there for extension of the maternity leave of 6 months. And that time the bank will give me only half salary. So these are the leave issues that employee contract is very, very important. In case I don't rejoin back, the bank has the right to dismiss me. They will call me, they will ask the reasons, and if I'm not giving suitable reasons, they have the power to terminate my services. Got me, all of you? Yes? And therefore, employee-employer contracts are very important. Now, in this case, that guy who joined the dockyard, he was given a notice that if you will not join back, we will withhold all your payments. Provident fund, pension, everything will withdraw. And they did that to him. They started the inquiry, they started the procedure, they gave him notice, and they did not pay him the money. They stopped all his payments. Now, this guy was very brilliant. He joined his LLB. The 3-4 years that the dockyard was, fighting with him of not giving any payments, he joined his law, and that period he utilized our services as faculties of law, and he became a good lawyer. And yes, the dockyard now answered him and gave him back all his rights. Got me? He showed some valid reasons, and we could make him say to it that he fought his own case. He fought his own case. So these are the termination clause, responsibility clause. Of course, yes, the employment contract should be specifying exactly what actions will result in termination. What are the actions? Maybe gross negligence, whatever. Maybe, untidiness, or maybe, dress code, maybe anything that is in the draft we write. And yes, it knows what activities is mandatory to their role of an officer or as a manager or as whatever, and he should have, the company policy should be respected. Company policy should be respected. So in case if anything goes wrong, you have a termination notice given, and yes, they are given a notice, they have to appear and they have to speak, and this is called the principle of natural justice in law. Punch. Kindly write down punch. Punch. That's the principle of natural justice. If a person is supposed to be given a notice of termination, he has to be allowed to come in front of the management and explain why he should not be terminated, why his payments should not be withheld. Many of the cases that come down to us, they are not paid their provident fund, their pensions are stopped. So principle of natural justice, that's an opportunity to be heard. The employee is given an opportunity of being heard. All of you, I won't be going back to this. There can be a case study. If I am the paper setter, I might put for you. So the principle of natural justice says that an opportunity has to be given, opportunity of being heard has to be given, so that the party, the person who is defending himself is in a position to say that this was my condition, I was suffering from such and such thing, I cannot travel all the way through the train to the dockyard, and I was getting scared that I might die of an heart attack, so I thought of buying a new house, a small shop, and I thought if I'll sit and see that, then I can resign, I can take my VRS. So all these things, they speak to the panel. They speak to the panel, and the panel decides that, come on, let us give him justice. So that's the principle of natural justice. The principle of natural. In Western countries, we are having the Fair Act, Fair Work Act, wherein they don't terminate easily. They don't terminate easily. Yeah. Employees in SOAP, we will be doing a case study today. Someone will be speaking to you, one of your friend will be speaking to you the Jet Airways case, wherein the Jet Airways is in the SOAP, and you saw when he was flying out of the country. Who is the person who was flying out of the country? Yes, can somebody be that person? Jet Airways owner? Who is Jet Airways? Vikas, who is the Jet Airways owner?
Ma'am, Swati.
Swati?
Yes, ma'am.
Swati is the observer. I want from the class somebody. Swati is our observer, whether they are speaking properly.
Okay, ma'am. Okay, ma'am.
Someone from the class, Jet Airways owner?
मैम वरुण
जोर से बोलो ना.
वरुण मैम
Varun, come on the screen now, Varun. Okay, Varun is the Jet Airways owner. What's your name, Jet Airways owner?
Naresh Goyal.
Yes, yes. So you were planning to fly away from the country, right? And who stopped you in the international airport? Who is our ED in the class? Who is our ED in the class? I wanted an ED in the class. Enforcement Directorate.
Ma'am, can I be?
Yes. Yes. What's your name?
Okay.
Surbi. So Surbi is the Enforcement Directorate officer, and I want a CBI officer. Surbi.
Shoma.
Yeah. Yes. What's your name?
Surbi ke mami.
Surbi, both of you have to introduce yourself. The CBI and the ED has to inform yourself. Please. Who is the other one? I want an ED officer, CBI officer. Come on, we are going to do case study. Your answer sheet has case study, so you people have to express yourself what is happening exactly. You have to know that the National Company Law Tribunal exists, 2013 Act, the Indian Companies Act 2013, we are having a National Company Law Tribunal. Surbi, you are the ED officer, right? Yes.
Yes, ma'am.
Why did you arrest him? Why do you want to arrest him?
Because he was going to walk away from the um, organization and gonna dispose all it on the land, the flights.
He's going to run away from India, right? But
Yeah.
you had some proof that he had done some foreign exchange violations. Yes, you had some files, no, with you. You had
Yes,
some
ma'am.
files with you that Jet Airways has done something. Mr. Goyal
4
has,
months without
yes,
pay.
yes. No, that is something which he has done for his employees. But as an ED, you're bothered about the foreign exchange regulations, your violation of
Okay.
foreign exchange regulation. So you want his custody, and so you were not allowing him to fly away from the country, right? Right? Yes.
Okay.
Along with you,
Yes,
there
ma'am.
is CBI also waiting for him. The CBI also did not allow him to fly away. He took an objection, and next day you all moved the court. You all moved the court, and the court also did not allow him to fly away. So who won? Who won? Did Naresh Goyal won or you won in the court? You won, na?
Me.
Yeah, you the
Yeah.
investigating officer won.
Investigating
Right?
officer.
You the investigating officer. See, these all are very important in your Indian Companies Act, the next module. The next module, Indian Companies Act, you're having a chapter on investigation. And while investigating, these officers are very important. These officers are very important. The RBI cannot arrest. Though the RBI is making the law of foreign exchange. The RBI, we are having the exchange control department. In my 5th module of banking, we will be doing exchange control. And in exchange control, we are having the exchange control department where the RBI makes the laws Foreign Exchange Management Act. Okay, as a regulator of banking. Fine. But the Reserve Bank of India officers cannot arrest him. Who can arrest him? You. You have the
The
power to
investigative
arrest him.
officers.
Yeah, you have the power to. The RBI will give away the files to the ED, and the ED will arrest him. Okay. So you were in the airport.
Okay.
You were in the airport, and you did not allow him to enter the flight. Once he enters the flight, then you cannot handle him. Once he enters the flight, you cannot handle him because that may be, flight of other
Out
country.
of the city.
So the other country
Yeah.
law starts. The other country law starts. So before he was there in the airport, you were arrived. You arrived there and you hold him. Okay, you did not allow him to. So this is the Jet Airways scam. Fine. Somebody will be speaking to you today about what happened. Okay, so he has to pay. The CBI is over there because he did lots of offenses, that is PAPI, prejudicial and affecting public interest. I want a CBI in the class. Who's that? Come on, D division. One guy. Yeah.
Ma'am,
Who's
it is
that?
again Vishal Mehta, but nobody's coming forward, so why not?
Wait, I'm going to catch them in the question answer session. Okay. So Vishal is again one of the officers. So why he wants Naresh Goyal's custody? Both of you are going to file petition. Both of you will be present in the court. We will not allow him to fly away from India. Okay? Because he has done something prejudicial. He has done some acts which is there in the Indian Penal Code. Okay? He has done some acts which is prejudicial and affecting public interest. So therefore, the court will listen to you and will not allow him to fly away from India. Okay? Yes? So this one, Swati Menon will be explaining to you later on in the class. Okay? Fine.
Yes.
So the employees in SOUP, inability to pay debts and salaries. Yes. Of course, the Jet Airways has been grounded, and naturally crores of rupees salaries to be paid to the pilots, right? They're not been paid. They worked, they slogged, they went to international countries, they did their duty, but payment not given. So they all were actually on the streets. So the NCLT agreed for the insolvency petition of Jet Airways, and you will see that now the insolvency law also we will be learning in one of our session on insolvency law. Okay, on insolvency law, 5 of you will be enacting this particular case of Jet Airways. Okay, the NCLT tribunal accepted the insolvency petition, and people are stepping in so that they get some, justice. They get some justice. So you will see the terminated employees sitting over there. They want their job back. They want their salary. The pilots are all they're not having job, but most of them, some of my friends working for Jet Airways, luckily they have got into Air India. Luckily they have got into Air India, but many of them are still unemployed and unpaid. So you will see that a consortium of banks is going to help them out in the National Company Law Tribunal. And yes, once again, the terminated employees may get a chance to work for Jet Airways. So very, very important is the liquidated damages clause. The liquidated damages, employees generally have the liquidated damages. Yes, I told you it's a pre-estimated damage. It's a pre-estimated amount which is decided over there. Data privacy. Data privacy, of course, is very, very important. The clause which says that India has not enacted a specific legislation pertaining to data privacy, but under the Information Technology Act, we have a section where, yes, that is 43A and section 72A, which gives a right to compensation for improper disclosure of personal information. Okay, so these are the data privacy laws. We'll see once again the data privacy, that is, it is pertinent to note, considering section 27 of the Indian Contract Act, Section 27 of the Indian Contract Act, the Supreme Court has observed that it is implicit in contract of employment. It is very important in a contract of employment that an employee should not disclose any confidential information of his former employee. Okay, so in case this happens, exemplary damages have to be paid. Now here, the data protection clause, that is GDPR, a clause to be inserted in the employment contract, which sets out the employer's right to process data in accordance with the privacy notice, and in which the employee agrees to comply with the employer's privacy. So these are the clauses where we attempt to write extremely, very, very important statements in the clause, because if anything goes wrong in the court, we should get justice for the party, for the aggrieved party. So the data privacy law is very important. It comes under the confidentiality clause. Yeah. As per the Indian law, confidentiality clause is a non-disclosure clause in a contract, and it bounds two or more parties or all the involved parties, yes, to ensure and agree that specific type of information that is furnished by one party or all the parties will remain confidential. So, when people work for me also, I handle very sensitive cases. Maybe I don't allow the press to come near me because very, very sensitive cases these are. Especially when we handle cases of 376 or maybe something which is very, very damages to the reputation of a person, criminal offenses, and those people come down to our office, discuss everything. So that particular moment of time, we either remove our junior lawyers out. We don't allow them to be in the meeting. We don't even allow them to know the identity of the person who is getting arrested. So these are the confidentiality clauses which we see to it that they have to listen, because if it leaks out in the press, then that particular person who has been adjudged and accused, who has to prove his innocence, will be affected. So therefore, even in business transactions or maybe in employer-employee transaction, confidentiality clause is very important. We always mark a file confidential. We mark a file and keep it separate and write there, no one is supposed to touch this. This file no one will be having. So you will see in organizations also, if you are observed to be very, silent and very good at your job, you will be picked up for that job. You will be having all the confidential information. You will be seeing to it that that this whatever has been told to be by my top management, it should not be leaked out. It should not be leaked out, because if the press comes to know, then that particular corporate reputation, the damage happens, and even the brand image of that corporate goes down. So naturally, confidentiality clause is very important. So confidentiality information in this agreement or clause, confidential information means information of confidential nature, whatever form, which relates to the purpose and is disclosed by the either party, that is a discloser, or any officer, any director, any member, anybody, partner. We'll do the partnership also. In partnership laws also, when we make an agreement for a partnership firm, we particularly write the confidentiality clause. So yes, the confidential information may arise from any one of the party. It may directly or indirectly the recipient's authorized person also. So maybe today I'm not over here, so one of my junior may see this file and he'll have to go to the Supreme Court to take care of my client whose name comes in the press often. So he will be having the right. So maybe my authorized person who can have the access to my files over here. So these are confidentiality. So disclosure, very important clause over here is the disclosure. The person who discloses information, we should have the right to protect his image. So naturally, the disclosure clause is very important, both in employment and contractual obligations. Yes. Important clauses in corporate and commercial agreements. Similar, we also saw the 5 important clauses in commercial agreement. One was the confidentiality, one was the obligation, third was the force majeure, fourth was the jurisdiction, fifth was the
Trigger.
alternate dispute redressal,
Termination.
then
Trigger.
7
Termination.
And
damages clause, right? Similarly, in contractual obligations, rather than making a contract, we can also make an MOU. MOU is a memorandum of understanding. So here it is not enforceable in the court of law. Just I'm making an MOU for 2 partners that for 2 parties that they may enter into a contract in future. Okay, they may enter into a contract in future. So important clauses in contract include such as attributes of termination clauses, confidentiality. Agreements are involved, yes, in nearly all the industries. We do it, whatever they are doing, small things. Nowadays, even 10 lakh or 5 lakh also, they prefer to go for a lawyer who will make the deed. In partnership, it is called the partnership deed. So the next session we will be doing on partnership. Now here we are having the indemnification in employment contract. One of you, our observer, is going to explain to you the indemnification clause. Again, indemnification is either of the party will step into the shoes of the other in case there is a loss. So that is the indemnification clause. One of you will be speaking. I think so. It's breakup time right now. CR.
Yes, ma'am.
From the videos.
Yeah, we'll have to show the video. Yeah, can you show the video right now?
Yes, ma'am.
Yeah.
I'll share
You
this.
have the course. Yeah, once you have the course, right, na?
Yes, ma'am. I'm sharing the screen right
Just show them, no? Just show them.
Ma'am, you need to stop sharing your screen.
Yeah, I'll stop share. I'm just saying what I have to talk afterwards. Afterwards, we'll be doing the different types of business entities. What's happening? 1 second, Vansh. What's happening? Let me see. Vansh, which is the video you want to show?
just a second.
Yeah.
When individuals become employees, they take on both employment rights and responsibilities. Those obligations can be spelled out formally in a written employment contract or more.
Yes, why?
When individuals become employees,
Can you see the video?
Yeah, yeah.
When individuals become employees, they take on both employment rights and responsibilities. Those obligations can be spelled out formally in a written employment contract or more likely in an employer handbook and policies disseminated to employees. Contracts formalize the employment relationship. An employee's contractual rights are based on a specified contract with the employer. For instance, a union and an employer negotiate a labor contract that specifies the terms, conditions, and rights that employees who are represented by the union have with the organization. The contract also spells out the company's rights and obligations. Traditionally, executives and senior managers have negotiated individual employment contracts, but they are now becoming more common for highly specialized professional and technical employees who have scarce skills. An employment contract is a formal agreement that outlines the details of employment. An employment agreement should address all particulars of the employment relationship, including base pay and incentive compensation, basic and supplementary benefits and prerequisites, key job functions and performance criteria, the contract term, and terms and conditions for terminating employment. Employment contracts may include non-compete agreements, which prohibit individuals who leave an organization from working with an employer in the same line of business for a specified period of time. A non-compete agreement may be presented as a separate contract or as a clause in an employment contract. The courts use the following guidelines to determine whether a particular non-compete agreement is acceptable. First, it sets limits on the expectations of employees not looking for work elsewhere. A typical duration is under 2 years, restricts activity to a logical geographic scope, grants employees additional consideration beyond regular employment, limits employers from working within the current area of specialization, but does not prohibit employment in new fields. Contracts may also include non-piracy agreements, which bar former employers from soliciting business from former customers and clients for a specified period of time. Clauses requiring non-solicitation of current employees can be incorporated into an employment agreement. These limitations are created to protect the organization from former employees attempting to recruit former coworkers or clients, essentially poaching talent or business. An area often covered in employment contracts is protection of intellectual property and trade secrets. A 1996 law made theft of trade secrets a federal crime, punishable by a fine of up to $5 million and 15 years in jail. Employer rights in this area include the following: the right to keep trade secrets confidential, the right to have employees bring business opportunities to the employer first before pursuing them elsewhere, a common law copyright for works and other documents prepared by employees for their employers. The rights and responsibilities of the employee may exist only as unwritten employer expectations about what is acceptable behavior or performance on the part of the employee. Some court decisions have held that if an employer hires someone for an indefinite period or promises job security, the employer has created an implied contract. An implied contract is an unwritten agreement created by the actions of the parties involved. Such promises establish employee expectations, especially if there's been a long-term business relationship. The employment relationship is affected both by formal and informal agreements. The rights and responsibilities of the employee may be spelled out in a job description, an employment contract, HR policies, or a handbook, but they're often not.
Yes, thank you all of you.
I'll share the another video.
Yeah. Just do it first because we can do the next session properly then.
How to choose between the different types of business entities. There are 4 types of business entities: business, company, limited liability partnership, and limited partnership.
1 second, Vansh.
The simplest form, which is a business. A business can be a sole.
Yeah, the class, the next session will be on different kinds of business entities. We have finished the contract law. The entire 7 sessions of contract is over. From today onwards, we will be starting the business entities, the LLP, the partnership, the company law. Yes, thank you, Vansh. Yeah.
Partnership with 1 owner or a partnership consisting of 2 to 20 owners. Business owners are personally liable for the debts and losses of the business. This is known as unlimited liability. Next, let us look at company. A company usually has the words PTE Ltd or Ltd as part of its name. One of the advantages of owning a company is that the shareholders have limited liability. This means that they are not personally liable for the debts and losses of the company. For the 2 partnerships, let us see how they differ. For limited liability partnership or LLP, it is a partnership with a minimum of 2 partners and they have limited liability. In limited partnership or LP, there needs to be a general partner and a limited partner. Whilst the general partner is personally liable for the debts and losses of the LP, the limited partner enjoys limited liability. Now that we've gone through the different entities, ask yourself the following questions. Would you like to own the business by yourself or together with other people? How much capital are you prepared to invest? Are you able to finance your business solely, or do you need finance from other persons? Would you prefer limited or unlimited liability? If you're finally ready to decide on an entity, make sure to adhere to the following rules. You are at least 18 years old. All business entities must have at least 1 person who is residing in Singapore. For business, LLP and LP, there is a requirement that the owner or partner's Medisave must be paid up with the CPF board at all times. If in doubt as to which business vehicle to register, you may wish to start a business first and register a company once your business picks up. Whatever business vehicle you choose to register, please ensure that you comply with all the requirements for registration and that you continue to comply with the post-registration requirements after registration. Best of luck!
Yeah, so all of you, we will meet after 10 minutes, 15 minutes. Yes. After 15 minutes, we'll start the next module of different kind of entities, business entities. I'll be introducing you to the very, very important syllabus of your exam. That's company law. We will be doing very important questions. So please, I will request you all to come fast. 3:30, right?
Yes, ma'am. Yes, ma'am.
3:30, 3:35, I will be starting the important features of a company, which is very, very important for your exam. Company,
Okay, ma'am.
why Subrata Roy is arrested. Okay, the question for your exam can be features of a company. Features of a company. So after that, I'll be moving to the partnership laws. First, I'll be introducing you to the very important concept of company. Bye.
Bye.
Yeah, thank you.
Thank you, ma'am.